full proper procedure, a warning, a disciplinary hearing, maybe an appeal in the school against the disciplinary hearing, maybe an appeal to the education department. If all the proper procedures were followed and they reached the same conclusion, would you have been happy, or would you still have said the applicant's rights have been violated?
I think that if they had gone through the process, he would have...
We also have to be practical. You've done it on a very theoretical level. You've talked about people's dignity. But isn't the factual situation that this is a Jewish school, where, if I understand it correctly, 98% of the pupils are members of the Jewish faith? They also have certain traditions, if not rules, regarding clothing, etc. Do you think it is unreasonable of them not to want to see somebody who is extrovertly Rastafarian as their head boy?
I think, Your Justice, if he had taken, for example, he had gone and shaved a swastika onto his forehead, well, not forehead, sorry, the Jewish people in the school. However, it wasn't, wearing dreadlocks wasn't affecting anyone. He wasn't saying, oh yes, everyone, let's become Rastafarian now. It was merely his self-expression.
Always going to be an infringement of rights?
I think, Your Justice, to a certain extent, yes. Schools should have rules to create uniformity. But as I was saying, he wasn't affecting the school in a negative way. If the school had found a way to compromise with his hairdo, his hairstyle, then it would have been fair. However, they didn't. They took his disregard for the rules as something as it wasn't even as like complete disregard for the rules. But if they had sat down and they discussed it, then they could have reached a compromise. He wasn't affecting anyone. They could have simply just said, okay, keep it out of your face, keep it inconspicuous.
Unless I missed it, and just remind me again, I've not heard anything on the Equality Act yet. Section 14 of the Act, for example, it's a long section on unfairness. And again, as I understood the applicant's argument, well, that both sides were in agreement that discrimination occurred, but that the applicant would have argued that the discrimination was unfair, and the respondents would argue that it was fair. So I thought Section 14 of the Equality Act would have been an obvious starting point for the argument. Yet I've not heard anything explicitly on the Equality Act. Will anyone on the applicant's team have anything for us on Section 14 of the Equality Act?
The Equality Act, it doesn't really apply in this specific sense, because in the Equality Act, if I'm not mistaken, it does it protects religion and culture. And seeing as we've decided that it was more of a freedom of...
Afternoon, Your Justice. We are the respondents in the case of Joseph Meyer, and we submit that although discrimination has taken place, it is fair and therefore does not violate the standing constitutional law. We as the respondents agree that Joseph Meyer has been discriminated against. However, we do submit that the discrimination is fair due to the following.
Sorry to interrupt you, and you can continue just now. You know, you were going to talk now for quite a while, and you have a colleague also who I presume is also going to address us. Could you perhaps, as a kind of a summary, like the table of contents in a book, give us a roadmap or a quick summary as to which aspects are you going to address, and which of those are you going to do, and which ones are your colleague going to do? That would help us also to know how to deal with the questions that we may have in mind.
The factors that I will be dealing with are the fact that John Meyer is in fact not Rastafarian. So so basically I'll be basing my argument on that fact, and I'll also be talking about
the question at hand here is not whether he is practicing his religion, because according to the stated facts, Joseph Meyer is not a Rastafarian, and he has not converted to this religion.
can I just take you back one step? You said that a code of conduct, if a code of conduct allows for exemptions, does that not fly in the face of a commitment to diversity?
We as the respondents, we submit that although this is not a matter of whether he can, it's not a matter of diversity and religion, which religion he comes from. Because in the stated facts, it does say that the school does allow other religious, cultural, and cultural groupings to enroll into the school. So this is a matter of the fact that Mr. Mayor has broken a rule that is in the Code of Conduct. Particularly Chapter 2, Section 15, stipulates that everybody who has the sole right to celebrate their own religion. However,
Sorry, can I just ask you, was Mr. Pillay expressed?
We submit that Joseph Mayer, in wearing his hair in dreadlocks, is not his religion. Therefore, we as the respondents submit that this is not a matter of unfair discrimination, and Mr. Mayor should therefore not be allowed to wear his hair in dreadlocks. I will now hand over to my co-counsel, who will be elaborating.
Thank you, co-counsel. As my co-counsel has stated, the school may be held accountable of discrimination, but this has been done in a fair manner. For according to Section 5, subsection 2A, religious observations may be conducted at state and state-aided institutions, provided that these observations follow the rules made by the appropriate authority, which in this case is the school. Thus, Joseph going against the school rules.
Sorry, can you just say what did you call it? Section what?
Section 5, subsection 2A.
Of what?
Of the religious for discrimination. No, from the Constitution.
I have Section 5 in front of me. It says the national flag of the Republic is black, gold, green, white, red and blue. So maybe you're just confused with the document that you're quoting from. But seeing that you have mentioned so many different rights, perhaps you can mention the flag as part of the argument.
Can I ask you a question? You stressed quite a lot about the fact that, and your colleague has also mentioned,
That the court ruled in our favour in declaring fair discrimination by Pretoria Jewish School towards Joseph Mayer.
Can I just ask you, in all fairness, all that he did was to wear his hair in a certain...
It's fair in the sense that Joseph Mayer was given a code of conduct before he entered the school, and therefore he agreed to follow the school rules.
Did you indicate in the beginning that, or you or your colleague indicated that because he's a head boy, he's even more bound by the code of conduct? Is that what she said, or do you agree with it?
Yes, I do.